Welcome, curious minds. Ever find yourself staring out your window at, a crazy downpour, winds howling, and thinking, do I really have to brave that mess for work today?
Oh, absolutely. Or maybe you're on the other side, right?
Like an employer.
Exactly. An employer trying to figure out how to keep the business going, but also, critically, keep your team safe. It's a tough balance.
Well, if any of that sounds familiar, you are definitely in the right place today. We're going to try and cut through all that storm confusion and get to some clear skies, basically understanding work suspensions during bad weather here in the Philippines.
Yeah, and what it means for both employees and employers.
Right. It hits everyone.
It really does. And it's super relevant, especially, living where we do with the kind of weather we get. We've gathered quite a bit of info for this.
Oh, yeah. What kind of stuff?
Well, we've got the official advisories from DOLE, that's the Department of Labor and Employment, specifically Labor Advisory number 17 from 2022. It built on earlier ones.
Okay, so the official guidelines.
Right. But not just that. We also looked into, the real world side of things. What employees are actually saying, their experiences, kind of unfiltered.
Ah, the reality check. That's crucial.
It really is. Gives context.
Totally. So our mission today is basically to unpack all these guidelines, shine a light on the key facts, maybe the ones people miss, and just lay out really clearly who's responsible for what when the weather goes sideways.
Roles and responsibilities for everyone involved.
Exactly. We want you listening right now to feel armed with the knowledge you need, whether you're deciding about your own commute or making decisions for your company. Confidence and clarity, that's the goal.
Let's get into it then.
Okay, so first things first, the skies open up, maybe Pagasa issues a signal warning, and suddenly work suspension is all anyone can talk about, right?
It becomes the main topic, yeah. On group chats everywhere.
But here's where it gets a bit, tricky. It's not quite the same for private companies as it is for, say, government offices or schools.
That's a really important distinction. People often get confused there.
Right, because you see the news. The LGU, the local government unit, like the mayor, declares suspension for government work.
And schools, yep.
And people assume, okay, that means everyone. But not necessarily for private businesses. There's this idea that maybe DOLE issues a blanket suspension.
Yeah.
But that's not quite it, is it?
No, that's a common misconception. While the LGU can and does suspend work for public sector employees based on weather conditions.
Which makes sense for public services and safety.
Right. But DOLE itself does not issue those kinds of sweeping, mandatory work suspensions for private companies.
Okay, so if DOLE isn't making the call, who is?
Generally, it falls to the individual company. Private companies operate under their own internal policies when it comes to this.
Their own.
Now, those policies should absolutely be guided by occupational safety and health laws, OSH laws, and they definitely should consider what the LGU has announced. It's vital information.
But the final say rests with the company.
Pretty much. The default assumption for private sector work is that it's business as usual, unless the company itself makes a formal announcement saying otherwise.
Okay. So that leads us to this big concept, this power the employers have. What's it called again?
Management prerogative. That's the legal principle at play here.
Management prerogative sounds powerful, like they can just decide whatever they want. But surely there are limits, especially when safety's involved.
Oh, absolutely. It sounds broad, but it's definitely not unlimited power. That's where the crucial details come in.
So let's dig into that. What exactly does management prerogative mean in this context?
At its core, it's the employer's inherent right to regulate, according to their own discretion and judgment, all aspects of employment. Hiring, work assignments, discipline, and yes, deciding on work suspensions.
Managing their business, essentially.
Right, how they see fit. But, and this is the huge caveat, it must be exercised in good faith.
Good faith. What does that mean practically?
It means the decision can't be malicious or intended to deliberately harm employees or used as a way to get around labor laws or existing agreements, like a collective bargaining agreement, a CBA.
So they can suspend work for safety, which is good faith.
Exactly. Or decide to continue operations if it's safe and necessary for the business, but they can't say suspend work just to avoid paying people if there's no real safety issue. That wouldn't be good faith. It's a balancing act.
Balancing business needs with employee rights and safety.
Precisely. Prioritizing safety and health has to be a major factor, especially during bad weather. The goal should be to advance the business without trampling on employee rights.
And there's legal backing for this specific idea.
Yes. You see it referenced in court decisions. And importantly, DOLE's own labor advisory number 17, the one from 2022, explicitly says employers may suspend work. It uses the word may, indicating discretion.
Not must.
Correct. They may suspend work precisely to ensure the safety and health of their employees during weather disturbances. It grants them the authority, but frames it around safety.
Okay, that makes sense. It's a power tied to a responsibility for safety.
And interestingly, the advisory also suggests how that decision should ideally be made. It's not meant to be just one person deciding in isolation.
Really? What does it suggest?
It emphasizes making the decision in coordination with the company's safety and health committee, safety officer, or another responsible company officer.
So involving the safety experts within the company.
Exactly. It promotes a more collaborative, informed approach. Someone whose specific job is to think about worker safety should ideally be part of that conversation. It reinforces that employee welfare is paramount.
Less likely to be purely a profit-driven decision then.
That's the intention. And this focus on safety, on potential harm, leads us straight into a really critical concept for employees in these situations.
Which is?
The concept of imminent danger.
Okay, imminent danger. That sounds serious. So we know employers can suspend work, but what if they don't? Or what if you, as an employee, look outside and think, there's absolutely no way I can safely get to work? What power do you have?
This is where Labor Advisory 17 really empowers employees. It hinges on that idea of imminent danger.
So what legally counts as imminent danger? Is it just feeling unsafe, or is there a specific definition?
There's a legal definition, yes. It comes from Republic Act 15058, the OSH law we mentioned earlier. It defines imminent danger as a condition or practice in any place of employment which could reasonably be expected to cause death or serious physical harm.
Okay, death or serious physical harm. That's a high bar, not just inconvenience.
Exactly. It's not about a heavy rain shower making your commute unpleasant. It's about conditions, maybe severe flooding, risk of landslides, flying debris in a typhoon that pose a genuine, immediate threat.
Right, a real risk to life or limb.
Precisely. And recognizing that threshold is key because it unlocks a significant right for the employee.
Which is?
The right to refuse work. The advisory is incredibly clear on this. It states, and this is powerful, that employees who fail or refuse to work by reason of imminent danger resulting from weather disturbances shall not be subject to any administrative sanction.
Wow. Okay, unpack that. No administrative sanction. What does that mean in practical terms? No warnings, no firing.
Exactly. It means your employer cannot legally punish you. They can't give you a written warning, suspend you, fire you, or take any disciplinary actions simply because you decided the situation was too dangerous to report to work, or maybe even to stay at work if conditions deteriorated badly.
That is huge.
Yeah.
So you literally have the right to say, my safety comes first, and the law backs you up.
That's the essence of it. It reinforces the fundamental right of employees to prioritize their personal safety over workplace obligations when faced with a credible, imminent threat. It's a critical protection.
That sounds amazing on paper, but let's be real for a second. How often do employees feel genuinely safe enough to use that right? Is there sometimes maybe unspoken pressure, fear of being marked as difficult even if they can't technically be punished?
That is the crux of the matter, isn't it? The gap between the legal right and the lived reality. The law provides the shield. It empowers the employee to make that safety call without fear of formal reprisal.
But the culture.
But the workplace culture, the pressure from supervisors, the fear of subtle retaliation, those things can absolutely make it difficult for employees to feel comfortable exercising that right. It's something we hear about a lot, especially, as we'll discuss, in certain industries.
Right. We'll definitely circle back to that reality gap. But, okay, assuming safety's handled, either work is suspended or you've decided not to go, and the very next question everyone asks is?
Money.
Always.
Yeah.
The big one. Will I get paid? What if I only worked for like 3 hours before they send us home?
Yeah. The wage question is immediate. And the DOL advisory provides very specific guidelines here. It's crucial for everyone to understand these. Let's break down the scenarios.
Please do. Scenario 1. You didn't work. Either the company suspended operations or you didn't go in due to imminent danger.
Okay. In that situation, if work is unworked, the general rule applies. And that rule, fundamental in Philippine labor law, is no work, no pay.
Ah, so generally no pay for that day.
Generally, yes. If you didn't render service, you're typically not entitled to your regular pay for that day. It's straightforward on the surface.
But you said generally, which implies.
Exceptions. Exactly. There are important exceptions. The no work, no payroll doesn't apply if there's a favorable company policy in place that explicitly says you will be paid.
Like if the company handbook promises pay during suspensions.
Precisely. Or if there is a long-standing company practice of paying employees during calamities. Or if it's stipulated in a collective bargaining agreement, CBA, for unionized employees.
Okay, so company policy, practice, or CBA can override the default rule.
Absolutely. They always take precedence if they are more beneficial to the employee. And there's another option. Employees can choose to use their accrued leave credits.
Like vacation leave
Mm.
or the service incentive leave.
Exactly. SIL, VL, maybe even emergency leave if the company offers it. You can apply your leave credits to cover those unworked hours or that day, and then you'll receive your pay as if you took a regular paid leave.
So you have options to avoid losing pay, even if the default is no pay.
Yes, that provides a buffer.
Now, that point about company practice is interesting. If a company has, say, always paid people during typhoons for the last 10 years, can they suddenly stop and say, nope, DLE says no work, no pay now?
Ah, you've hit on a vital principle. Non-diminution of benefit.
Non-diminution, meaning you can't reduce existing benefits.
Exactly that. It's rooted in Article 100 of the Labor Code. If an employer has consistently, voluntarily, and unconditionally granted a benefit over a long period, like paying wages during past calamities, that benefit becomes an established practice. It's essentially integrated into the employee's terms of employment.
That becomes a right.
Effectively, yes. The employer cannot then just unilaterally withdraw or reduce that benefit. So even if the DLA advisory states the general rule is no work, no pay, if the company has an established practice of paying, that practice is protected by the non-diminution principle. They can't just take it away.
That's a really strong protection for employees based on past employer actions. Good to know.
It is. Consistency matters. Now let's look at the other main scenario.
Okay, scenario 2. You did work. You braved the storm, got to the office, maybe worked a full day, maybe only part of it.
Right. If work is worked, even during the calamity, the rules are different here. If you report and work for at least 6 hours.
6 hours or more.
Yes. Then you are entitled to your full regular pay for that day. Simple as that. You put in a substantial workday, you get your full day's wage.
Okay, makes sense. But what if it's less than 6 hours? Like you worked from 8 a.m. to 11 a.m., then the flooding got bad and it sent everyone home.
If you work less than 6 hours, then you receive a proportionate amount of your regular pay.
So pay for the actual hours worked. If you work 3 hours out of an 8-hour day, you get 38ths of your daily wage.
Precisely. It's calculated proportionally based on the hours rendered. But again, this comes with the same important caveat.
Let me guess. Unless the company has a better deal.
You got it. Always without prejudice to existing company policy or practice more beneficial to the employee. So if your company policy says, show up at all during a typhoon, even for an hour, and you get the full day's pay, then that more generous policy applies. The law just sets the minimum standard.
Got it. Minimum is proportionate pay, but better company policies prevail. Now, what about those folks who really go above and beyond? The ones who make it in despite everything, maybe even get stuck at the office overnight. Is there anything extra for them?
That's a great question, and the advisory actually encourages something here. It explicitly encourages employers' encourages, not mandates, to provide extra incentives or benefits to employees who report to work during these difficult conditions.
Like hazard pay or just, a thank you.
It could be various things. The advisory suggests it's to support them and acknowledge their dedication. So yes, maybe a risk allowance, maybe free food, which is common, maybe covering transportation costs if they incurred extra, maybe providing temporary lodging if they can't get home safely.
So it's not required by law, but it's strongly recommended as good practice.
Exactly. Good corporate citizenship. It could even be factored into performance reviews, acknowledging someone who stepped up during a crisis. These things build enormous goodwill. It shows the company actually sees and values the effort.
Definitely fosters a loyalty, I imagine. Okay, so the legal framework seems pretty clear, with rights for employees and responsibilities for employers. But, here comes the reality check part. The law is one thing on paper, right? What we've seen, especially from discussions online, suggests that what actually happens on the ground can be, well, wildly different, particularly in certain sectors, like BPO, business process outsourcing.
Yes, this is where the disconnect often becomes starkly visible. The disparity between those legal provisions we just discussed and the lived experiences reported by many employees, especially in the BPO industry, is significant.
What kind of things are people saying?
Well, you see recurring themes. A very common sentiment, often expressed in Filipino, is something like, walang pakialam dahil lang dahilan nila nasa abroad naman daw ang pagsisilbihan.
Which means,
Roughly, they don't care because their reason is that the clients they serve are overseas. The implication is that foreign clients, unaware of local typhoon conditions, demand uninterrupted service, and that pressure overrides local safety concerns.
so a feeling that the demands of international clients trump the safety of local employees.
That's the perception reflected in many comments. Another one you see is, kahit nasa labor code yan, papagalitan kapag di ka pumasok.
Even if it's in the labor code, you'll still get scolded if you don't come in.
Wow.
I mean,
It speaks directly to that fear we mentioned earlier. Even if there's no formal administrative sanction, the fear of informal punishment, being yelled at, getting badmouthed, maybe impacting future opportunities is very real for some. It creates a business-as-usual pressure cooker, regardless of the storm raging outside.
man, that really paints a picture. And it explains those, frankly, kind of dark jokes you hear, like employees being called waterproof or being told they'll become immortal because they're expected to show up no matter what.
Exactly. Those comments capture the deep frustration and the feeling of being expendable.
I even saw that Reddit comment you mentioned earlier.
Yeah.
Someone's team leader literally told them during a flood, Magdala ka lang salbabida.
Just bring a life vest.
Just bring a life vest. It's almost unbelievable, but it highlights the absurdity and the danger some employees feel pressured into facing. A really stark contrast to the imminent danger protection in the law.
It really is. And these aren't just isolated jokes. These anecdotes, shared informally online, point to systemic pressures. Stories of team leaders using guilt trips. Well, other team members managed to get here.
Ugh, the guilt trip, classic.
Right. Or demanding really excessive proof if someone calls in absent due to flooding, like needing a certification from the local barangay captain just to prove their street was impassable.
Which is often impossible to get during the actual emergency.
Exactly. It creates unnecessary hurdles and stress during an already difficult time. These experiences, highlighted on platforms like Reddit's RBPO, NPH, and reported in news outlets like Interaction, show a reality where operational targets sometimes seem to completely eclipse employee safety and the spirit of the labor advisories.
It really does feel like, as one person put it online, the law seems alien compared to what's actually happening sometimes. Two different planets.
It can certainly feel that way.
But the good news is awareness seems to be growing, right? People are
Yeah.
talking about this more openly.
Yes, definitely. That's a hugely positive trend. And social media has played a massive role. We've seen human rights lawyers like Chel Diokno and various TikTok creators making content specifically about these labor rights.
Like at San Fernando Valley, you mentioned.
Yes, people like them are breaking down Labor Advisory 17 and RA 11058 into easily digestible formats. Videos explaining the right to refuse work, the pay rules, reaching millions of people.
So knowledge is spreading, empowering workers.
Exactly. The more workers know their rights, the harder it is for those rights to be ignored. It's a crucial step in closing that gap between the law and the lived experience. Awareness is the first defense.
And if someone is facing pressure or feels their rights are being violated, there are official channels to report it, right? They're not just stuck venting online.
Absolutely not. DOLE provides avenues for help. There's the DOL hotline, 1349.
And it's pretty accessible.
Very. They state it's 10-47 on weekdays and even has long hours on Saturdays, 6 a.m. to 10 p.m., which is great coverage.
That's really good. What about non-phone options?
You can also reach out via their official Facebook page, send messages there, or email them directly at Email Protected.
Okay, so hotline, Facebook, email, multiple ways to seek clarification or file a complaint.
Yes. Knowing these resources exist is vital. It gives employees a way to push back against unfair practices and helps hold employers accountable to the standards set by law. It's about making those legal protections actually work in the real world.
Okay, so we've really zoomed in on the specific rules for bad weather and work suspension. But you mentioned earlier how these rules connect to the bigger picture, the overall labor code of the Philippines.
Exactly. The principles governing wages during calamities aren't just standalone rules. They fit within a much broader framework of how wages must be handled, period. Understanding these fundamentals strengthens an employee's position overall.
So let's broaden out. What are the absolute bedrock responsibilities employers have when it comes to paying their employees day in, day out?
Okay, let's look at some key employer responsibilities under the Labor Code regarding wage payment. These apply universally. First, the form of payment.
How they pay you.
Right, Article 1 or 2 is very clear. Wages must be paid in legal tender. That means actual Philippine pesos, cash, or, by extension, through means that give you immediate access to legal tender like bank checks or direct deposit via ATM payroll, which are common and permitted now.
So no IOUs or company store coupons.
Absolutely not. The law explicitly prohibits payment by promissory notes, vouchers, coupons, tokens, tickets, chits, basically anything other than legal tender. This prevents historical abuses where workers couldn't freely spend their earnings. Payment must be real money you can actually use anywhere.
Got it. Cash or its direct equivalent. What about when you get paid?
The time of payment. Article 103 mandates payment at least once every 2 weeks or twice a month, and the interval between paydays cannot exceed 16 days.
16 days maximum gap. That's specific. So the common 15th and 30th, 31st schedule works, but isn't strictly required as long as the 16-day rule isn't broken.
Correct. Employers have some flexibility on the exact dates, but not on the frequency or the maximum interval. And importantly, monthly pay is not allowed in the Philippines.
No monthly paychecks. Needs to be more frequent.
Yes. And linking back to our topic, if a force majeure like a huge typhoon makes timely payment impossible.
Like banks are down, roads impassable.
Right. Genuinely unavoidable circumstances. The employer must pay the wages immediately after those circumstances have ceased. They can't use the disaster as an excuse for indefinite delay. Prompt payment is still required once feasible.
Okay. Form of payment, time of payment. What about where?
Place of payment. Article 104 says payment should generally be at or near the place of undertaking, meaning the workplace. This was designed to stop employers making workers travel far just to collect their pay.
Which sounds archaic now with ATMs.
Largely, yes. ATM payroll has made this less of a practical issue for many, but the principle of convenience and not burdening the employee remains.
Makes sense. And who gets the money? Can my boss pay my spouse if I owe them money?
Direct payment. Article 105 is strict here. Wages must be paid directly to the employee to whom they are due.
My money is my money.
Exactly. The employer generally cannot pay anyone else, not a spouse, parent, creditor, unless there are specific limited exceptions.
Such as?
One is during force majeure, if direct payment is impossible, the worker can give written authority for someone else to collect it for them. Doesn't need to be super formal, just clear written permission.
Okay, written permission in an emergency.
The other is in the sad event of an employee's death. The employer can pay the deceased worker's wages to their legal heirs, typically upon presentation of an affidavit, without needing lengthy court proceedings. DOLE can help facilitate the fair distribution among heirs.
Got it. Direct payment is the rule, with very specific exceptions. Now let's flip it. What are employers absolutely prohibited from doing when it comes to wages?
Right, the prohibited acts. This is where the law puts up strong fences to protect employees. We already mentioned one big one, non-diminution of benefits. Article 100. Can't take away established benefits or practices.
Crucial. What else?
Non-interference in disposal of wages. Article 112. Employers cannot in any way force or compel employees to buy things from them or anyone specific or use specific services. Your paycheck is yours to spend freely. No company store mandates.
Freedom over your own earnings.
Absolutely. Then there's wage deduction. This is a really big one, tightly controlled by Article 113. The starting point is employers generally cannot make deductions.
No deductions is the default.
Yes. Deductions are only allowed in very specific listed circumstances.
Like what? What can they deduct for?
Okay. The allowed deductions are 1. Insurance premiums, but only if the worker consents. 2. Union dues, again, only with authorization or if it's part of a CBA checkoff. 3. Things mandated by law, SSS, PhilHealth, PAG, IBIG contributions, and withholding taxes. These are legal requirements.
Okay, government contributions and taxes. Standard stuff.
Yes. And 4th, deductions for payments owed by the employee to the employer or a third party, but only if the employee has given express written authorization. And even then, the deduction can't be so large that the employee doesn't have enough left for basic living needs.
Written authorization is key there. So what about things like, say, lost or damaged company equipment? Can they just take that out of your pay?
That's very restricted. Article 114 actually prohibits employers from requiring past deposits from workers to cover potential loss or damage unless it's a recognized industry practice or specifically allowed by DLA rules.
So no mandatory deposit just in case you break something.
Right. And Article 115 says that for actual deductions for loss or damage, 2 conditions must be met. 1, the employee must be heard on the matter they get a chance to explain, and 2, the employee's responsibility for the loss or damage must be clearly shown.
Due process, essentially. Prove it was my fault and let me defend myself first.
Exactly. You can't just be charged arbitrarily, especially if the damage happened due to something outside your control, like a power surge during a storm while working from home. The burden of proof is on the employer, and fairness is required.
Good to know. What other prohibitions are there?
Several more key ones. Withholding of wages and kickbacks, Article 116. Unlawful to hold back pay or force an employee to give back part of their wages through intimidation or threat. Consent must be totally free.
No extortion.
None. Deduction to ensure employment, Article 117. Can't deduct wages as a fee for getting hired or keeping your job. No paying for the privilege of working there.
Right. No placement fees taken from wages.
Correct. Retaliatory measures, Article 118. Employers cannot punish an employee, cut pay, fire them, discriminate just because that employee filed a labor complaint or testified in a labor case. Protects whistleblowers and those seeking their rights.
Protection against revenge.
Yes. And finally, false reporting, Article 119. It's unlawful to knowingly make false statements or records related to labor standards required by the code. Ensures honesty in documentation.
Okay, quite a list of protections. Anything else significant in this broader wage context?
One last important point. Worker preference in case of bankruptcy, Article 110. If a company unfortunately goes bankrupt or is formally liquidated,
What happens to unpaid salaries?
the unpaid wages and other monetary claims of the workers get first preference in the settlement of the company's debts. Before the government gets its taxes paid, before other creditors get paid, the workers' claims on the available assets come first.
So workers are prioritized creditors.
Essentially, yes, for their unpaid wages. It doesn't create an automatic leave me before bankruptcy, but once bankruptcy or liquidation is declared legally, worker claims jump to the front of the line for whatever assets remain. It's a crucial safety net in worst-case scenarios.
Okay, wow. We've gone through the legal nuts and bolts, the official guidelines, the harsh realities, and the fundamental labor code protections. So bringing it all together, what does this mean for listeners navigating these messy situations? How do we move beyond just minimum compliance?
That's the million-peso question, isn't it? How can companies and employees actually partner effectively when the weather goes wild? It's about going beyond just ticking the legal boxes.
Towards what? Better practices.
Exactly. Best practices. Many companies, especially those that really value their people, already do this. They have robust business continuity plans that are about more than just systems. They're about supporting the workforce.
So while the law sets the minimum, some companies choose to do more.
Absolutely. And it pays off in loyalty and resilience. Think about it. The law might allow no work, no pay, but a company that chooses to pay its employees anyway during a major disaster.
That sends a powerful message.
It really does. Or companies that automatically waive absences or tardiness caused by the calamity so employees don't have that extra stress. Or those providing actual risk allowances, free meals, maybe even temporary shelter for those who do come in or get stranded.
Those extra incentives we talked about.
Yes. Even just formally recognizing exceptional effort during performance reviews. These aren't legally required, but they demonstrate genuine care and build incredible goodwill.
Yeah.
It's good corporate citizenship, plain and simple.
It sounds like investing in your people during a crisis.
That's exactly what it is. And another huge best practice, obviously accelerated by the pandemic, but incredibly relevant for weather disturbances, is embracing flexible work arrangements.
Work from home.
Work from home where the job allows it. It's often a perfect solution. Business can continue, at least partially. Productivity isn't totally lost. But employees stay safe. They're not risking dangerous commutes.
It really does seem like a win-win. Safety for the employee, continuity for the business, shows adaptability too.
It does. It shows the company trusts its employees and prioritizes their well-being alongside operational needs. It requires clear protocols, good communication, maybe some tech support, but the benefits during disruptions are immense.
Communication seems key in all this.
Absolutely critical. Probably the most important thing is for companies to have clear, easily accessible, well-communicated policies specifically for these situations.
No ambiguity when stress levels are already high.
Precisely. Everyone should know. Under what specific conditions will work be suspended? What are the exact pay rules if you work, if you don't work? What are the procedures for using leave credits? What are the protocols for WFH if that's an option? How do you report if you can safely come in?
Clarity prevents confusion and anxiety.
And builds trust. When employees know what to expect, they feel more secure and supported even when things outside are chaotic. Ambiguity just breeds fear and resentment.
Makes total sense. Ultimately, it really circles back to that core idea of safety first, like that quote you found.
Yeah, the simple wisdom. Huwag mong pilitin kung di talaga kayang magbiyahe.
Don't force it if you really can't travel.
It captures the essence. Your safety, your life is more important than any single workday. And the law, at its best, supports that fundamental truth.
We have definitely covered a lot today, from the specifics of DOLE advisories to the bedrock principles of the labor code and that essential reality check from actual employee experiences. If there's one key takeaway, it's that knowledge is power here. Understanding your rights and responsibilities, whether you're an employee or employer, is absolutely crucial when facing these weather disruptions.
Absolutely. Let's quickly recap the highlights. Employers have that management prerogative, allowing them to suspend work for safety, but it must be used in good faith, ideally with input from safety officers.
And employees.
Employees have the critical right to refuse work due to imminent danger, a real threat of serious harm without facing penalties. That's huge.
And the pay rules.
Generally, no work, no pay if unworked, unless company policy, practice, or CBA says otherwise, or you use leave credits. If you do work, you get full pay for 6 hours or more, proportionate pay for less, again, subject to more beneficial company policies.
Plus all those underlying labor code rules about fair payment, no illegal deductions, and worker preference in bankruptcy.
Exactly. They form the foundation.
So for you listening, next time the storm clouds gather and the rain starts pouring, remember this. Your safety has to come first. The law provides protections. Use them. Don't feel pressured into unsafe situations.
And for employers listening, prioritizing your team's well-being isn't just about being nice or following the rules. It's a fundamental ethical and legal imperative. It builds trust, it builds loyalty, it makes your entire organization more resilient in the long run. It's just smart business.
Well said. It prepares everyone to weather the storm, literally and figuratively.
Which brings me to a final thought, maybe something to ponder. As we see climate patterns changing, potentially leading to more frequent and intense weather events,
A very real possibility.
how can workplaces move beyond just reacting and complying with the minimum regulations? How can we proactively build a culture where employee safety and well-being aren't just an HR policy, but are deeply integrated into every single operational decision, especially when facing these environmental challenges? What would it look like to set a truly new standard for responsible employment in the face of a changing climate?